Ladies and gentlemen, good morning. My name is Marcin Kadunski. I'm in-house counsel for the government of Poland. I have this pleasure of chairing this panel. It's a great privilege, of course, because I was a visiting scholar here in BICO 14 years ago. So it's good to be back here. BICO has evolved, of course, in good direction. I see some similar faces over here, but also new faces and new developments. And new topics that have been discussed by BICO, and that's always very informative and thought-provoking. Okay, but we have the panel today: exhaustion of domestic remedies, res judicata, and international domestic courts. I start with presenting our panelists, Mr. Brad Fatala, sorry for my pronunciation. Bradin Pratt, a partner, he's a member of the member of the firm's international arbitration team. He acts as counsel in large scales and complex investment commercial arbitrations. And we have as a second panelist, Chloe Caswell. Chloe, are you with us? Good morning. How are you today? Can you hear us?
Good morning. I can. Thank you very much, Marcin.
Okay, great. Chloe is also Reed Smith, partner, member of the firm's international arbitration team, and also acts as counsel in large scales and complex arbitrations. And last but not least, Alex Slade, also a partner in the International Arbitration Group in the Dispute Resolution Department. Mishko Dereya, sorry for pronunciations again, mispronunciation. Okay, and our panel is again exhaustion of domestic remedies, res judicata, international domestic courts, interaction with domestic courts. Very entertaining topic. I would say this always appears when you are in investment arbitration lawyer. There's always at some stage you will find interaction with domestic courts, parallel proceedings, anti-suit, anti-arbitration injunctions, interim measures, so on and so forth. So you can see this topic from very different perspectives. For example, to one of the main proposals of investment arbitration, I think this is what I believe in, that is to avoid the use of domestic courts. But of course, whether we like it or not, the ISDS has to interact with domestic courts, especially in case of parallel proceedings, anti-suit injunctions. I can mention, for example, European cases, LWE versus the Netherlands, where we have an anti-suit injunction, and the whole discussion before domestic courts and also in the academic. So you can see these topics from you can identify a number of typical forms of interaction between domestic courts and international investment tribunals. Some of these interactions are regulated by treaties, some are by customary international law, and others have been developed by the jurisprudence. And this interaction, I think, may be broken down into following categories. First, prior use of domestic courts. Second, competition between investment tribunals and domestic courts. Third category is support by domestic courts in investment arbitration, and this may be referred to as complementarity. Fourth, interference with domestic courts in investment arbitration. Fifth, mutual scrutiny of investment tribunals and domestic courts. And sixth, how and to what extent res judicata estoppel may interact with the decision of domestic courts. So my first question would be for Brad. I would like to give you the floor about what I just mentioned, complementarity, but also perhaps rivalry between investment tribunals and domestic courts. Brad, the floor is yours, please.
Thank you very much, Martin. Thank you. Good morning, everyone. It's a great pleasure to be here, to be back at the Investment Treaty Forum, and I'm one of the probably oldest participants in this forum since my days as student, so it's always good to be back. And since then, I've been to many events, some of which 10-15 years ago discussed the same topics, which is refreshing because it shows that all of these topics remain timely. Now, unfortunately or fortunately, I was given a very challenging task of providing an overall sort of overview of the interaction between domestic courts and investment treaty or ISDS tribunals. As you can imagine, this would entail discussing many topics, each of which would warrant be it a conference on its own or a doctoral thesis. Therefore, I will have to sort of you will forgive me actually if I cannot really get into the details of some of these issues, some of which will be addressed by other panelists, others will just have to go quickly over them. But I would mention them at least to try to illustrate what trends seem to be emerging or keep on emerging, or how some principles keep on evolving, be it in the good direction or maybe sometimes even more, maybe confusion being created. Now, when one talks about interaction between domestic courts and ISDS tribunals, I mean, this really varies between, as Martin has said, between two poles, namely, as I put it, a complementarity and competition, you see. And I think for those of us who have acted as counsel or arbitrator in these type of cases, I can rarely think of a case that did not involve, as put by our keynote speaker this morning, that does not involve some sort of an interplay, be it a competition or support between local courts or ISDS tribunals. And that's why when I talk about complementarity, I say that this encapsulates the idea of a mutual support and collaboration between international and domestic tribunals. So one can also look at it on the positive side, whereby the proposition is that domestic courts and investment treaty tribunals can complement each other in the delivery of justice at different stages of the life of the cycle of a dispute. And here I cite two functions as an example, one of support and one of supervision. And I'll give a couple of examples. When we say support, it's essentially support in the enforcement and the assistance of where one forum can assist in the enforcement of a ruling, be it a procedural order or an award rendered by another a tribunal. Now, although arbitral awards are considered to be binding, the prevailing party may often need to resort to domestic courts to be able to enforce an award in the absence of voluntary compliance with an arbitral award or a procedural order. And I just can cite a recent example where one can see a helpful sort of a curial intervention, if I may say, with respect to a procedural order in the case between the Republic of India and Vedanta Resources in 2021, which related to an arbitration initiated against India under the UK India BIT. And here, India, the applicant in this case, before the state courts in Singapore, tried to obtain a declaration that certain confidential documents could be disclosed in another arbitration. Although the tribunal on the Vedanta arbitration had earlier rejected this request. So on 21 May 2021, the Singapore Court of Appeal found that the true purpose of the declaratory relief sought by India was a backdoor appeal against the procedural order issued by the tribunal, which was improper. And as the tribunal put it, because the arbitral tribunal is the master of its own procedure. And the Singapore Court of Appeal held that if a party to an ongoing arbitration proceeding puts a question of law to an arbitral tribunal and receives an answer which it does not like, it cannot put the same question before a Singapore court, i.e. the seat, by way of an application for a declaratory relief. Such conduct amounts to an abuse of process. Another example of a supportive function of domestic courts, as I mentioned, would be with respect to the enforcement of ISDS awards. And I mean, we don't need to get into it, but as you all know, the basis of the judicial intervention in the review or in the enforcement of exit awards is very limited, if not inexistent, and with respect to non-exit awards is very, very limited. That being noted, one classic hurdle to the enforcement of exit awards pertains to sovereign immunity. And recently, we see a trend appearing whereby we have two different approaches adopted by different domestic courts with respect to the onus of proof and how the onus of proof is allocated, basically in terms of establishing the sovereign use of the funds that are contemplated for the seizure. So I cite just two couple of examples to show you how two different courts took two different approaches. On the one hand, we have the Hydro versus Albania case of March 2022, whereby a judgment by the Brussels enforcement judge, Philippe Baudou, the claimant had succeeded in that case in enforcing an exit award in Belgium, freezing the money owed to Albania by the European Organization for the Safety of Air Navigation, Eurocontrol, which is a Belgian-based entity tasked with collecting charges earned by the states in relation to air traffic activities taking place in the jurisdiction. The judge in this case in Belgium rejected Albania's sovereign immunity plea as Albania had not presented sufficient evidence that all monies owed by Eurocontrol to the state were used by Albania in support of governmental non-commercial activities. Indeed, airspace charges could be used to generate profits and a reasonable return. On the other hand, the Dutch courts in Stati versus Kazakhstan, later on in June 2022, the Hague Court of Appeal lifted a 5.2 billion attachment order imposed on Kazakhstan's sovereign wealth fund as part of its efforts to enforce an energy charter treaty award against the state. Here, the Dutch Court of Appeal held that the sovereign fund was immune from attachments by claimants who had failed to present sufficient evidence that the assets are not intended for public use. So it shows you that basically these type of notions keep on evolving as we speak in practice. Now, investment tribunals also, they find themselves seized with remedies relating to the non-enforcement of judicial or arbitral awards. And there, of course, I'm sure you are all aware of plenty of examples. But in particular, ISDS arbitration or ISDS tribunals are often used as a forum for adjudicating a state's non-compliance with a domestic court decision or even an arbitral award. And here I cite two series of examples. One of them with respect to the non-enforcement of domestic court decisions. In a recent case in which I was involved, the claimant had obtained 3 favorable decisions from the domestic courts, and that's the case called Imperial Holding and Abu Jaouni versus Lebanon, where I defended Lebanon. And in that case, the claimant put forward arguments of violation of the effective means standard and claimed denial of justice by the respondent Lebanon, arguing that the state authorities had failed to enforce court decisions rendered in the claimant's favor. Now, the tribunal in that case dismissed both allegations. It concluded that the claimants failed to establish a breach of the effective means standard, as the standard did not include the situation where there's an alleged failure by the executive to enforce judicial decisions. The denial of justice claim also was dismissed because of claimants' failure to avail themselves of the various local remedies that could have been pursued in order to enforce the relevant judicial decisions which were favorable to claimants. Another category of intervention by ISDS tribunals with respect to the non-enforcement of awards. I'm sure you're all familiar with the older jurisprudence, the Saipem versus Bangladesh case, later on the Frontier Petroleum versus the Czech Republic, and more recently, White Industries versus India, where the claim itself is linked to the non-honoring by a party of an arbitral award. Now, just to cite an example, in the White Industries versus India, that's where the tribunal found that a 9-year delay in the enforcement of a New York Convention award, which had been rendered in favor of the claimant against Coal India, a state-owned company, amounted to a breach of the effective means standard under the Australia-India BID. Here, I just refer very quickly to a lecture given back in 2013 by Professor Gabrielle Kaufman-Kohler to show you how 10 years earlier, she had the vision, and then what we see today and what I'm trying to describe keeps on being a reality. And that's where she raised or asked herself whether this development points to a shift from the conception which traditionally assigns the last word to national courts or at the annulment or enforcement stage towards a new role for international courts or tribunals called to exercise a sort of a supervisory role over domestic courts conduct relating to commercial arbitration, meaning that the supervisory function of the state courts asked to enforce the arbitral tribunal is itself being controlled by yet another forum, being the ISDS tribunal. Now, irrespective of all of the underpinning questions that may arise, notably what exactly is the notion of investment with respect to the enforcement or not of an award or judgment, I would tend to agree that here the trend put forward by Professor Kaufman-Kohler is there to stay. Now, in addition to the sort of this dynamic role of mutual support in giving effect or facilitating the enforcement of awards, the flip side of the coin is that role can also be used to block the enforcement of decisions or awards by a party that is not satisfied with the outcome. And here, I'll try to be very brief. We all know that the possible avenues of judicial interventions are arguably limited in view of the pro-arbitration friendly approaches taken by most jurisdictions. That being noted, I can cite one example of one of the most arbitration-friendly seats, France, where I'm based, just to give you how now we're moving towards sort of, I would say, potentially more restrictive trends. In France, the level of scrutiny has increased recently with respect to public policy, and particularly when it pertains to issues of corruption. So for many years, under French case law, the courts would basically favor a very high standard of review to determine a violation of international public policy. Such violation had to be flagrant and concrete, and then the tribunal would only, the courts would only look at the effects of the award on the French legal order, not its content, which would not be examined. Now, we have noticed a trend or a shift since 2014, where now the standard of review has become more strict, and whereby the courts not only inquire if there's a flagrant violation of international public policy, but they actually accept to review the content of the award without being bound by the findings of the arbitral tribunal on public policy matters. And also from a process or procedural point of view, the French courts would actually accept new evidence at the stage of the enforcement or the annulment, and accept circumstantial evidence in cases of corruption and money laundering. So that's a trend that now is actually, we can see it impacting greatly the way arbitrators seated in France are conducting their arbitration, even if a state or a party raises post facto or opportunistic corruption allegations in a proceeding. And here, I would just cite one example, and I invite you to look at it because for the benefit of time, is the 2017 Belocon ruling by the Paris Court of Appeal, where that case involved money laundering allegations of a Latvian investor in Kyrgyzstan, whereby the Court of Appeal in France disagreed with the tribunal's finding on the evidence of money laundering and took into account new evidence, and the Court of Cassation confirmed this new approach. And another trend, and I would be very brief on this one, of course, in terms of intrusion or intervention by domestic courts into ISDS, is basically sort of the intra-EU debate and the issue of the sort of the ACMEA and the Constroy, and of course the PL Holdings versus Poland decision. So I will not touch upon those because I'm sure there were many investment treaty fora dedicated to that, or we can leave it to the discussion later. Therefore, we see a trend. Another trend that I would flag is that domestic courts do not shy away from conducting a de novo review of certain key jurisdictional determinations on certain public policy issues. Inversely, also we see an increasing frequency whereby parties are adjudicating the correctness of a domestic judicial finding. Now there, we all know, and I'm sure you have read many papers, we've had many conferences, we all agree that it is not the function of ISDS tribunals to serve as appeal tribunals. It's not an appeal mechanism for commercial, for domestic judicial decisions. But however, there is an acknowledgement that there is a certain power of review. And then a state, as we all know, can be found liable based on the conduct of its judiciary. It suffices to here refer to the concept of denial of justice. It is tried law that the test for establishing denial of justice is a very high one. We all know that. I will not get into it. That's another doctoral thesis. Many books have been written on this. But it suffices to say here that certain elements of the legal standard remain debated, such as the exhaustion of local remedies. And I know that Chloe will be touching upon this, but which is often not covered by international investment agreements as an admissibility requirement, but which may become relevant as part of the merits analysis of a denial of justice claim. And here I cite as an example, and I invite you to look at it, a recent case, which is Big Sky Energy Corporation versus Kazakhstan of 2021, where the tribunal found that the claimant's failure to exhaust local remedies was quite detrimental to its denial of justice claim. Then there's a more nuanced approach, also in a recent decision in Lyon, Mexico, Consolidated versus Mexico, whereby the tribunal held that the exhaustion rule is subject to two categories of exceptions, whereby an aggrieved alien is only required to pursue remedies which are reasonably available, which have an expectation that they will be effective, i.e. that the measure or appeal has a reasonable prospect of correcting the judicial wrong committed by the lower court. And here I skip to leave the opportunity to Chloe, I would believe, to expand on this. But it shows you that the exact contours of the exhaustion of local remedies requirement as an element of denial of justice analysis seems to be crystallizing as a matter of case law. Then, if we move on, basically, here we can start seeing an element of tension. So there's the complementarity, but then there's an element of tension, which is normal because when we, in this area, in this field, we are dealing with different legal orders that are interacting, and which it's normal in certain instances for the various competences to clash, for tensions to arise, and there will be points of frictions that are inevitable. But again, I think we have the tools, be it in terms of treaty drafting or in terms of arbitral interpretation, to deal with these issues. And I will try to be fast on those. Here, basically, we see that tribunals, there is some sort of an effort of coordination, you know, and one can actually see that there are attempts to sort of clarify certain issues. Yet, let me start maybe with the more sort of touchy point, more as a point of tension. There are attempts, and one can look at it in different ways and have different points of view about this, of attempts of judicial intrusion by domestic courts into the ISDS sphere. They are still relatively rare because of the competence principle, of course. But I can cite simply, again, the recent example of the intra-EU objections. And there, for example, there's the Netherlands versus RWE and Uniper case, where the higher regional court of Cologne granted the Netherlands request made despite the exclusivity rules stipulated under Article 26 of the Exit Convention for a declaration that the Energy Charter Treaty claims by 2 German companies were inadmissible. So there the court acknowledged, you know, the relevance of Article 26, yet basically there was, you know, and it recognized that the Exit Tribunal retained the duty to make its own decision on the issue of their jurisdiction. Yet it opens here again some zone of ambiguity, and it remains to be seen how this decision would have an impact on future tribunals. But again, I would not touch upon it in greater detail. So here, if we put intrusiveness aside, there's also a role for ISDS tribunals in terms of the overlap to come and support basically a situation that is happening on the ground, and their provisional measures. We know that ISDS tribunals under the Exit Convention rules and other rules, they do have the power to order provisional measures. We know that the standard is quite high. One has to establish that there would be an irreparable harm and that at least substantial harm. There we know that attempting to obtain provisional measures with respect to domestic court proceedings, such as trying to halt criminal investigations or criminal proceedings, is quite rare. It's quite difficult. Yet it shows you that there's a certain role, if calibrated properly, to be played by ISDS tribunals. And I can cite like a quick example in a case that is not yet published, whereby in a case I'm acting as counsel, just after we had the first session in an Exit Tribunal, bankruptcy proceedings were started against claimant, my client, and the claimant was not notified of a hearing in the bankruptcy proceedings that was going to take place 2 days later. So we asked the tribunal for a temporary restraining order, which we obtained, to request the respondent state to adjourn or delay the hearing to allow claimant to participate in the proceedings. And there, like in most, I would say, provisional measure requests where tribunals are very careful not to intrude on the sovereignty or the powers of local courts, it was basically captured under the sort of the non-aggravation of dispute heading, whereby the tribunal issued a TRO or temporary restraining order, ordering the state to cause its instrumentalities, I'm reading, to refrain from adopting any measures with respect to the claimants would otherwise aggravate the dispute and the arbitration, noting that objecting to a request for a reasonable adjournment of the local court hearing, the bankruptcy hearing, would contribute to aggravate the dispute. And this actually had an impact later on the conduct of the proceedings because the state did not comply with that TRO. So I'm mindful of the time, and there I would just mention some topics where there is clear case law clear doctrine, a clear evolution in the interpretation of certain principles that allow for a coordination through arbitral interpretation, through case law of the interplay between domestic courts and ISDS. There we have the fork in the road clauses, we have the waiting period clauses, we have the exhaustion of local remedies, which will be discussed in a moment. And of course, there's the the distinction between contract claims or treaty claims. So those four notions, which of course I see that I don't have time to go through, we almost find them in the majority of cases. Fork in the road clauses are present about 23% of BITs worldwide. There is recent case law touching upon the interpretation of these clauses, such as the Bank Meli versus Bahrain award. And these are meant to avoid parallel proceedings. And then they raise numerous questions about the clarity of their wording or not, whether they are actually fork in the road clauses or not, such as in the Selmani versus Kosovo case, which I mentioned just in passing. And also, and I think Alexander will be covering those, so maybe I should not delve too much into it. And tribunals have actually taken different approaches to try to deal with those issues. There's the issue of the triple identity test that one sees how this would evolve. Then you have the waiting periods. These are sort of the cooling off periods. These are present in 90% of BITs. Again, there have been difficulties or issues with interpreting these cooling off periods. And again, what are the consequences of not respecting these provisions? Are they mandatory? And what are the consequences of the failure by a claimant not to honor the cooling off period? Is it an issue of jurisdiction or admissibility? And then there's also the futility exception. I'm sure you're all aware of it, and whether this can serve as an implied excuse for the investor not to comply with the waiting period. And again, I just mentioned the Casino Austria versus Argentina case that looked at this issue. And then, of course, there's the interpretation of the contract claim, distinction between contract claims and treaty claims. We've been discussing this for 20 years now. And I'm sure you're all too familiar with the SGS Pakistan cases and then whatever case law followed from that. And that basically one would think that the issue has become clear, but then again, the tribunal have a thin line to walk because so often the claims, the facts are so intertwined that drawing the line between what is a contract claim, what is a treaty claim, is not always as systematic, always as easy. But that's something where I say that the case law is evolving. It keeps on evolving, and I give you just two recent examples of cases involving state contracts, which normally would contain their own exclusive dispute resolution clauses, whereby tribunals today are can look at contractual claims under the lex contractus, as opposed to looking at them from a perspective of an international law claim, while applying the distinction between contract claim and treaty claim. And that's the KCI versus Gabon case and the Consutel versus Algeria case. And that shows you that today, even tribunals, while applying the distinction, can actually also manage the situation of a clash or conflict between jurisdictions over these type of different claims, while focusing on applying a different lex arbitrary. Lex contractus, forgive me, the lex contractus. So I would basically simply conclude by saying that, and of course there's the Strabag case versus Libya, where the tribunals can sometimes put aside exclusive jurisdiction clauses if it's considered that it's actually inefficient or unrealistic to go through these through these channels. So by way of conclusion, I hope I just gave you a flavor of all of these issues, which remain today quite important to discuss. They remain in evolution. I think we've made a huge progress in terms of interpreting some of these notions and some of these tools that can help tribunals, but also counsel, to manage the interplay between domestic courts and international tribunals. I think the interplay, it's there to stay. The issues are there to be, to evolve even more. And I think if we see each other again in 10 years, we will be having the same discussion. Thank you.
Thank you much, Farid, for inspiring presentation and giving us some flavor of interaction between domestic courts and investment cases. And thank you for being kind enough to give some floor to Chloe regarding exhaustion of local remedies. Chloe, now the floor is yours. Please provide us with your views on this topic.
Thank you. Thank you. Good morning, everyone. I'm here today to speak about the domestic or local remedies rule in the context of international law. I'm going to race through my notes, so please do bear with me. I'm going to look at what it is, its application and any exceptions to it, and the issues that have arisen that may question whether it remains relevant. So back to basics, what is it? The requirement to exhaust local remedies is essentially the obligation on an individual to resort to all available and effective local remedies that exist in a domestic legal order. It has two applications in international law, in a procedural context and a substantive context. The main rationale for it is to allow the state, where the violation occurred, an opportunity to redress it by its own means within the framework of its own domestic legal system. This is quite a common theme. A state should be afforded an opportunity to right its own wrongs before being held to account on an international stage. Accordingly, the procedural requirement is rooted in customary international law, it's grounded in practical and political considerations, and serves as an established comity rule in public international law in favour of the host state. So in a procedural context, it's a prerequisite to the exercise of rights in three scenarios. Firstly, customary international law. Article 14 of the ILC Articles on Diplomatic Protection, as Sam was referred to earlier, requires the exhaustion of local remedies as a prerequisite for the exercise of diplomatic protection. This has been recognised in judgments of the ICJ, with the Chamber confirming it to be an important principle and a well-established rule of customary international law that cannot be tacitly dispensed with in the absence of any words making clear an intention to do so. Secondly, both the Human Rights Convention and the International Convention on Civil and Political Rights require all domestic remedies to be exhausted before bringing a claim under those instruments. So looking now at international investment law, in ICSID arbitration, the requirement to exhaust local remedies is not a precondition to a treaty claim. And this is because Article 26 of the ICSID Convention provides that an agreement to arbitration precludes the parties from seeking local remedies unless otherwise stated. It goes on to dispense with the automatic application of the local remedies rule and places the burden on states expressly to require it if they want to condition their consent to arbitration under the convention, thereby dispensing with the customary international law rule that applies by default in diplomatic protection and human rights cases. So for the local remedies rule to apply as a precondition to a treaty claim, the relevant treaty must require it. It will not be implied, and any attempt by a tribunal to do so will make an award susceptible to annulment. And that's what happened with Hellman Hotels in Egypt. The award was partially annulled for manifest excess of powers because the tribunal determined that Hellman was required to exhaust local remedies before commencing ICSID proceedings, even though the relevant BIT didn't require it. If there is no treaty requirement, consent to ICSID arbitration should be unqualified unless there is clear agreement between the parties on the point. In arbitrations under rules other than ICSID, the principle is the same, notwithstanding the absence of a provision equivalent to Article 26. Investment treaty tribunals have referred to the specific requirement envisaged in the applicable investment agreement, where those investment agreements were found to have waived the requirement to exhaust local remedies. That was the prevailing view in respect of NAFTA, or where they mandate a clear choice, as in the ECT, or where they contain provisions inconsistent with such a requirement, such as a fork in the road provision, or a particularly short cooling off period. Even where the treaty is silent on any specific application of the rule, the overwhelming consensus is that in the absence of any treaty language, the local remedies rule is not applicable in investment treaty arbitration unless otherwise provided for by the contracting parties. So as far as investment treaty arbitration is concerned, this makes sense. One of the purposes of an international investment treaty is to grant arbitral recourse outside the host country's domestic legal system. The clear purpose is to grant independent judicial remedies on the basis of an internationally accepted legal standard in order to protect foreign investments. As noted by the Rosinvest Tribunal, the consent to investor-state arbitration amounts to a waiver of the principle of exhaustion of local remedies. The mere fact of choosing international arbitration to settle third-party investment arbitration disputes necessarily excludes the principle of exhaustion of national legal remedies. To implicitly require the exhaustion of local remedies would, in the words of the EDF and Argentina Tribunal, be to invite states to mandate the exhaustion of local remedies without giving fair warning of such a stipulation to investors who enter a treaty expecting a clear path to arbitration. So the local remedies rule does not usually find application insofar as an investor's right to initiate an arbitration is concerned. It's not a precondition unless it's expressly required by the treaty. And this is typically either by states conditioning their consent to arbitration on the exhaustion of local remedies, or by treaties expressly requiring the exhaustion of local remedies prior to bringing a claim. Where there is a local remedies rule in an applicable investment agreement, tribunals have heard arguments on whether the precondition should be construed as an absolute bar, where it might result in pointless litigation, where recourse to domestic litigation is unilaterally hindered by the host state, and where the claimant and claims in the domestic court proceedings are different to the claimant and claims in the arbitration proceedings. Finally, in the procedural context, is the application of the local remedies rule a question of jurisdiction or admissibility? Article 44 of the ILC Articles on State Responsibility specifically provide that exhaustion of local remedies is a question of admissibility. Article 26 of the ICSID Convention sits under the heading jurisdiction. Arguably, it's a question of admissibility, as the failure to exhaust local remedies is a temporary rather than an absolute bar to the tribunal's jurisdiction, meaning simply that the claim is not ripe to be heard. The jurisprudence isn't clear either way, with investment tribunals hearing complaints from respondent states on both a jurisdiction and admissibility basis. In the substantive context, specifically in investment arbitration, the local remedies rule has two important applications which can make or break an investor's claim. Non-compliance with the substantive requirement makes certain internationally wrongful acts incomplete or not made out, namely in establishing a denial of justice and in a state's failure to comply with the effective means standard. So turning first to denial of justice, the jurisprudence is overwhelmingly in favour of the view that the exhaustion of local remedies is a substantive requirement for the occurrence of a denial of justice. An aggrieved investor, before proceeding against a state, must first have exhausted all legal remedies available in national courts and must have lodged appeals up to the highest instance, unless lodging an appeal would be obviously futile. This requirement guarantees that no cause of action arises in relation to a state's obligation to render justice if the investor has not attempted to exercise its rights, and that the host state's judicial system is provided with an opportunity to rectify errors in the decision of a lower court, and that international tribunals do not become appeal courts for dissatisfied investors. This is because, as Paulson confirms, the obligation on states under international law to protect individuals from the occurrence of denial of justice requires states to create and maintain a system of justice. For that reason, denial of justice does not occur until the entire judicial system is deemed to have failed to render that justice. Accordingly, state responsibility for denial of justice would not be engaged in principle unless the judiciary has rendered its final and binding decision. Because denial of justice deals with the failure of a system, not just a single court, it cannot be established until local remedies have been exhausted, thereby giving an opportunity for higher courts to rectify mistakes of lower instances. We're talking, therefore, about the demonstration by a foreign investor of a systemic failure in the judicial system of a host state. It is an elevated standard of proof due to the gravity of a charge which condemns a state's judicial system as having denied justice to an investor. The tribunal in Ústí and Slovak Republic described it as a failure of the national system as a whole to satisfy minimum standards. It is an international obligation to provide non-nationals access to justice and due process for the determination of their rights and duties through competent, independent, and impartial courts, according to internationally recognized standards. It is well settled that investment tribunals are not courts of appeal, and tribunals have repeatedly said so. It bears repeating that as a matter of international law, the state must be allowed to right its wrongs. Paulson states, for a foreigner's international grievance to proceed as a claim of denial of justice, the national system must have been tested. Its perceived failings cannot constitute an international wrong unless it has been given a chance to correct itself. Professor Paparinskis in turn states, it is accepted that denial of justice becomes internationally wrongful only after the whole system of administration has been put to the test by the exhaustion of local remedies. This view is endorsed by investment tribunals. The tribunal in Big Sky in Kazakhstan put it succinctly. The claimant's failure to exhaust local remedies is quite detrimental to its denial of justice claim. Whether such remedies would have been successful is not the issue, and of course cannot be known, and therein lies the problem. The claimant now claims to be denied justice when it failed to properly exhaust the local means by which it could have obtained such justice. Several other international law decisions support the conclusion that the state is not liable if the investor failed to take such domestic remedies. In Apotex in the US, the tribunal similarly noted that a denial of justice claim depends upon the demonstration of a systemic failure in the judicial system. Hence, a claimant cannot raise a claim that a judicial act constitutes a breach of international law without first proceeding through the judicial system that it purports to challenge, and thereby allowing the system an opportunity to correct itself. However, the requirement is not absolute. The local remedies must afford to the foreign national a reasonable prospect of correcting those deficiencies in a timely, fair, and effective manner. It requires that remedies be exhausted only once. It does not require appealing twice or more to the same court on the same matter, for example. The requirement is limited to reasonable attempts to right the wrong within the state's own legal system. The Lowen Tribunal stated that the availability of a local remedy is not a standard to be determined or applied in the abstract. It means reasonably available to the complainant in light of its situation. It must be available as an effective and adequate appeal within the state's legal system. It is not required where it would be evidently futile or unreasonable, such as when there is evidence of a manifestly defective judicial or administrative system. In the words of the Duke Energy Tribunal, as quoted in Saipem and Bangladesh, parties are not to be held to improbable remedies. Indeed, there are certain instances where the exhaustion of local remedies will not or indeed cannot be required in circumstances where the unsuccessful pursuit of domestic remedies itself constitutes a denial of justice in of its own right. An example of this is where there have been excessive delays in domestic judicial proceedings, or where access to domestic judicial proceedings is denied. In this situation, the tribunal in Avon and Costa Rica concluded that local remedies must have been commenced without result or are non-existent or illusory for a denial of justice to arise. Although it would be wrong in principle to require foreign investors to have pursued at the time any local remedy that lacked any reasonable prospect of a timely, effective, and adequate protection, the legal burden of proving such ineffective protection once a potential procedure has been identified by the respondent state rests upon the investor. The investor cannot justify a failure to pursue local remedies because of its assumptions regarding the anticipated rulings. It must show that an appeal would have been futile. The Big Sky Tribunal cautioned that to permit investors to successfully pursue investment treaty claims on what they assume would have occurred had they pursued available local remedies would be to open the floodgates to speculative claims based on what courts might have done if asked to address alleged legal wrongs. Secondly, effective means. An effective means clause requires a state party to provide an effective means of asserting claims and enforcing rights with respect to covered investments. Introduced and most often seen in US BITs, this provision is otherwise rare, appearing in only a handful of non-US BITs and the ECT. It requires the host state to establish a proper system of laws and institutions that guarantee matters such as legislation for the recognition and enforcement of rights, access to courts, due process, and rights of appeal. As such, it has been considered by some tribunals to implement and form part of the more general guarantee against denial of justice and the fair and equitable treatment standard. By contrast, at least 2 tribunals have held that an effective means clause constitutes a lex specialis, to which a distinct and potentially less demanding test is applicable as compared to denial of justice under customary international law. The tribunal in the seminal case of Chevron and Ecuador 1 provided a comprehensive analysis of the effective means standard, in which it qualified the otherwise strict application of the local remedies rule to denial of justice by stating that a claimant alleging a breach of the effective means standard does not need to prove that it has exhausted all local remedies. A claimant must, however, adequately utilize the means available to it to assert claims and enforce rights. It will be up to the host state to prove that local remedies are available and the claimant to show that those remedies were ineffective or futile. This analysis was followed with approval by the tribunal in White Industries and India. So issues arising. My final topic is the talking points that have arisen in the context of the domestic remedies rule. Thorny issues arise where tribunals are asked to consider whether judicial acts that fall short of denial of justice can nevertheless give rise to a treaty breach. This question, whether states can be held responsible for the acts of their judicial organs outside the context of denial of justice and without the satisfaction of the substantive requirement of exhaustion of local remedies, is quite a controversial subject. The tribunal in Arif and Moldova noted that the fact that the alleged wrongful acts mainly relate to acts of the judiciary does not necessarily mean that local remedies should be exhausted before an international claim can arise. A court may violate a BIT standard directly, and this breach will be attributable to the respondent state without there being any requirement to exhaust local remedies, unless it is a breach for denial of justice. For example, the substantiation of a breach of the fair and equitable treatment standard does not entail exhaustion of local remedies. The tribunal in Burlington and Ecuador held that a reasonable enough attempt to seek local redress on the investor's account satisfied the investment treaty claim to become mature and thus admissible. Likewise, in Saipem's claim for judicial expropriation against Bangladesh, while the tribunal concurred with the parties that expropriation by the courts presupposes that the court's intervention was illegal, this did not mean that expropriation by a court necessarily presupposed a denial of justice. Judicial expropriation is a concept which divides tribunals and commentators alike. Some investment tribunals have been reluctant to find judicial expropriation unless there was also a denial of justice or a lack of due process. Others have made findings of judicial expropriation on its own, as in Saipem, or contemplated that such finding was possible, even if judicial expropriation was not found in the case at hand. As a result, the application of the legal concept of judicial expropriation by investment tribunals is far from settled. Also unclear is whether exhaustion of local remedies is a requirement that applies equally to cases of judicial expropriation and other breaches by the judicial organs of a host state. The tribunal in Arif and Moldova indicated that exhaustion of local remedies would be required if the claim of judicial expropriation also amounted to a denial of justice. In Saipem and Bangladesh, the tribunal stated that it tends to consider that exhaustion of local remedies does not constitute a substantive requirement of a finding of expropriation by a court, but ultimately didn't make any determination to this effect, thus leaving open the question of whether exhaustion of local remedies is a general requirement for judicial expropriation. However, expropriation by judicial acts does not erase the requirement for a finding of expropriation which involves a final, definitive, irreversible, and permanent deprivation. There can be no such deprivation while there remain mechanisms to effectively remedy and reverse the position. Thus, an expropriation by judicial act necessarily entails a similar requirement to the requirement of exhaustion of local remedies to be made out. By contrast, an allegation of a breach of the fair and equitable treatment standard is different. This standard of treatment has a broader scope than the obligation to protect foreign investors against a denial of justice. It also involves the protection against violations of due process throughout the judicial process. A complete breach of the fair and equitable treatment standard for a violation of due process could, under some circumstances, emerge before all effective remedies have been exhausted. A breach could, for example, materialize when an investor challenges a ruling, brings objections and complaints, and/or attempts the judicial system to change the ruling before the same court or in the form of an appeal before a higher instance, even if it does not resort to and exhaust all possible effective remedies. The question, therefore, is whether states are gradually losing an important shield from their armory of defences. Does the jurisprudence suggest that local remedies rule is becoming less relevant? What seems to be clear is that where denial of justice is concerned, either directly or packaged as some other breach, such as judicial expropriation, the host state's court system remains sacrosanct, and a disgruntled investor will be expected to have exhausted local remedies before any claim for denial of justice, howsoever presented, will be upheld. Anything falling short of that standard may well be up for grabs. Thank you.
Thank you much, Chloe, for giving us an overview of the rule of exhaustion of local remedies. Now we move forward to the res judicata principle, perhaps its potential and estoppel. Perhaps, Alex, you can give us some background also in terms of case law, for example, Chevron saga or Karatube case. Please, Alex. Yes.
Thank you, and good morning, everyone. It's a pleasure to be here again and speaking on this great panel. I'll try and be relatively quick and leave some time for discussion at the end. I've been asked, as Martin just mentioned, to discuss res judicata and issue estoppel in the context of investment arbitration. We heard earlier from Sam a fair amount on some of these topics, and he put it much better than I will. So forgive me where I repeat to a lesser standard that which Sam has already traversed. But res judicata as a concept is one that is familiar to most, if not perhaps all, legal systems. But the form it takes in different legal systems, national legal systems at least, does vary. At a very basic level, the concept is really directed at avoiding unnecessary, duplicative, never-ending litigation. And there are two, I think, broad drivers for that within a national legal system context. The first principle is that one ought not to be sued twice for the same thing. You can't have another go if you don't like the first result, or if you've decided that you should have done it differently the first time round. Litigation should come to an end. It should have an end, subject to whatever the permissible appeals are within the system. And there's an obvious imperative to avoid duplicative proceedings. The second principle is an extension really of that, which is that in a national system, the state itself also has an interest in litigation coming to an end. In a national court context, states are provide court facilities, provide for the use of them, and there's an obvious need to control to some degree the way in which those resources are used, so that you don't have multiple proceedings that not only waste the parties' time and resources, but the states. So despite a common position that a doctrine of res judicata is necessary, different legal systems take different approaches, particularly when looking at a common law position as compared to civil law jurisdictions. To take the example of England from the common law perspective, we can identify a number of different concepts that together could be brought together under the broad heading of res judicata, such things as cause of action estoppel, issue estoppel, abuse of process, which Sam mentioned earlier, including within that the rule in Henderson and Henderson, which is the principle that if one commences a litigation, one should bring all the claims that one could have brought within that process and not split them up into multiple proceedings. I recall the very first true international arbitration I did as a junior associate, we had the late Johnny Vida on the tribunal, and we had, I think, about 100 files. Each member of the tribunal, each party had about 100 files stacked up behind them, apart from Johnny, who'd required that everything be sent on USB sticks, and he had the world's smallest Sony Vaio laptop in front of him, and that was it. And I don't recall him saying anything in the 2-week hearing, apart from interjecting in the middle of one of someone's submissions to say, well, it's Henderson and Henderson, isn't it? And then didn't really say anything more after that. That was my first exposure, and actually my first exposure to the rule of Henderson and Henderson in practice. I say these concepts can be gathered together under the banner of res judicata, but they are different concepts and they have different application. Cause of action and issue estoppel are more narrowly applied. They, to some degree, are closer to civil law concepts of res judicata. Abusive process and the rule in Henderson and Henderson work differently, and they are wider in their application. Most civil law jurisdictions often codify the concept of res judicata based on a triple identity test, and we've heard that mentioned already, which essentially requires the same parties, the same claim, the same cause of action. And within this context, it's often the case that only the truly dispositive part of a judgment produces res judicata effect, although that is not always the case, and some reasons that are necessary adjuncts to the decision can also have res judicata effect. So as I say, within the common law system, cause of action and issue estoppel are similar manifestations of the triple identity, but they're not the concept, but they're not the same. Issue estoppel in particular is a broader concept because it can, but as its name suggests, it's the issue that is looked at. So you can have a situation where the claim and the cause of action are different, but nonetheless, a party can be estopped from making a different argument on an issue that has been traversed in a previous case. Abusive process is a broader issue again, and it can apply where the parties are not the same and where the issues are not the same. Bernard Hernosio has referred to the Henderson principle as producing claims that could have been claims. So you could have brought the claim in an arbitration, but you didn't. By definition, those kinds of claims would fail the triple identity test because the new claim is obviously one that wasn't brought previously. So with that potted background, the question arises how the concept of res judicata translates into investment arbitration. It's been common ground in a number of cases that res judicata is recognized as a general principle of law within the meaning of Article 38, 1C of the ICJ statute. And one can look at the Waste Management in Mexico tribunal who noted that. And both the ICSID Convention and the New York Convention provide for arbitral awards to have preclusive effect, since they provide for them to be final and binding. And that brings into play these kinds of res judicata concepts. I think it's fair to say that the drivers for this principle are essentially the same as they are in the national context. Finality of arbitration is important both for the parties and also looking more broadly for the arbitral system. And there are a number of ways in which questions of res judicata arise or could arise in an investment arbitration context. As has been touched on by Raid, investment arbitration and by Sam actually in his keynote, investment arbitration doesn't exist in isolation. It's a part of what can be a tangled web of rights and causes of action, or at least routes of action at different levels. You have national courts, you have potentially multiple corporate entities within the same chain of investments. You can have multiple treaties that apply, and all of these areas give rise to possible issues of res judicata. One example is a claimant company within a chain that has a parent company, and both of those, both the claimant and the parent, have access to an investment treaty, maybe the same one or maybe different treaties. If both parties bring investment claims against the respondent state, can a decision in one of those cases have a preclusive effect in the other? And we've already heard reference to the prime example of CME, the CME and Lauder versus the Czech Republic cases. In that case, in those cases, as a reminder, Mr. Lauder controlled CME, and the decision lost that arbitration, and then a subsequent arbitration in the name of CME was successful, and there was the tribunal in that case didn't apply any res judicata effect to the award in the Lauder case. That essentially follows a sort of strict view of res judicata. The parties were not identical. So if you're looking at the triple identity test, it fails on that first point. But other decisions have trended away from that particularly perhaps strict view of res judicata and taken a more flexible approach. The RSM production in Granada tribunal considered whether in a very similar situation, a claim brought by the shareholders of a corporate entity, RSM, could proceed even though RSM itself had brought a prior claim. And it held in that there was an issue estoppel in that case because the shareholders were privies with RSM. Now the RSM tribunal also considered a separate requirement with the cause of action identity. And the argument in that case was that the prior arbitration by RSM was concerned with contract claims, whereas the second arbitration was concerned with treaty claims. The tribunal nonetheless found that an issue estoppel arose since the findings and decisions of the tribunal in the first arbitration on the various factual and legal issues were binding on the parties, even though the causes of action were different. And the tribunal noted that to allow effectively the prior award to be reopened effectively through the back door would be an abusive process. This approach can be contrasted with Helen International Hotels in Egypt, in which the tribunal carefully distinguished contractual issues from international treaty issues and found that a prior contractual arbitration did not have a res judicata effect on a subsequent treaty claim. And similar discussion in Karatu and Kazakhstan, in which again a contractual arbitration succeeded despite a prior unsuccessful BIT claim, so the other way around. And that decision is interesting in this context in that it focuses in part on the idea of an abusive process, which Sam mentioned earlier. And the tribunal in that case stated that an abusive process focuses not on the fact of multiple proceedings or on whether a particular claim or issue could have been raised in earlier proceedings, but on whether the assertion of such particular claim or issue in further proceedings constitutes an abuse. So focusing on this notion of abuse properly considered rather than simply the fact of multiple proceedings. And the tribunal treated that as a fairly high threshold, and in that case found that there was no abuse. But as again Sam identified earlier, these issues are not easy to cover in cases, and this can be contrasted with the Orascom and Algeria case, where we had a parent company commencing arbitration against Algeria in circumstances where its Egyptian subsidiary had already commenced a BIT arbitration, and the tribunal in the latter case considered the claimant had committed an abuse of rights by using corporate entities with essentially the same economic interest to start parallel proceedings. Now, turning back to the issue of identity of the parties, again, Sam referenced it earlier, but the tribunal in the Apotex Holdings case considered the effect of the earlier NAFTA award between Apotex Inc. and the US on the parent company, Apotex Holdings, subsequently brought a claim, and the tribunal held that the parent company was bound by the first award because it was a privy with its subsidiary, again, the same idea as in RSM, and notwithstanding the fact that the claimants were different. Now, in that case, the tribunal went on also to consider the scope of the res judicata principle. Now, Apotex had argued that the relevant issue in the second arbitration had not been part of the dispositive section of the award in the first arbitration, and so could not produce a res judicata effect. But the tribunal found that the operative part of the first award could and should be read with the relevant reasons given for it. And the tribunal held that in the first case, the parties put distinctively in issue sorry, I'll just clarify. The point, the case is concerned abbreviated new drug applications, or ANDAs. In the first case, the dispositive part had dealt only with what were called tentatively approved ANDAs, whereas the second claim, the Apotex was saying, was focused on finally approved ANDAs, so they were two different things. So the tribunal held that the parties put distinctively in issue ANDAs generally, not limited to tentatively approved ANDAs, but also including finally approved ANDAs. The tribunal actually decided the issue, and that, as the tribunal saw it, that decision was necessary to resolve the parties' dispute. And on that basis, it had been traversed in the first award, and it would be given a res judicata effect. And this approach can be traced back to AMCO Asia and Indonesia, where the tribunal noted that a right, question, or fact distinctly put in issue and distinctly determined cannot be disputed later on. So, as we can see, the approach to res judicata issues is not consistent. Despite a number of cases staying close to the triple identity test, others seem to have moved more towards a flexible approach. While there is little consensus on some of these points, I think we can perhaps see a trend to move towards this more flexible approach, or at least to consider its application. But it's not easy to do in particular cases. One question where this has not, I think, reached a resolution is the question of whether a prior decision in a case can have res judicata effect or not at a later stage of the same case. This is particularly the case in an ICSID arbitration, since the ICSID Convention doesn't provide for partial awards, so you may have a decision on jurisdiction and then a later request that that decision be opened up. That's exactly the question that was discussed in the recent case of Cavallum and Spain. Spain had applied for reconsideration of the tribunal's prior decision on jurisdiction, in which jurisdiction had been upheld, and this was an intra-EU ECT case. And the tribunal agreed in considering this with a comment of the tribunal in Standard Chartered Bank and Tanzania. As an essential feature of res judicata is that the judgment that is said to have preclusive effect produces effects outside the proceedings in which it is granted. A decision on jurisdiction within an ICSID procedure does not have that outside effect, only a final award does. And on that basis, the tribunal found that its prior decision on jurisdiction did not have a res judicata effect, could be reopened. The tribunal noted there was contrary jurisprudence on this point and rejected the claimant's reliance on a number of cases, including Perenco in Ecuador, CMS gas transmission in Argentina, waste management in Mexico, Electrabel in Hungary, and ConocoPhillips in Venezuela. And in doing so, the tribunal essentially noted that a number of those cases hadn't really given much in the way of reasons for their decisions, and that's why it was discounting them. All of that said, the tribunal's ultimate decision in that case was that it would open up its prior decision on jurisdiction, but not change it. And perhaps stepping back, that's not an unsurprising result. In that case, the tribunal found that the issues that Spain wanted to reopen had been considered by it in its prior decision, and so there was no need to change the case. The same tribunal looking at one of its prior decisions is probably going to need a lot of persuasion or a very definitely new piece of information to be persuaded to change its mind. So to conclude, there has been some criticism, we heard this earlier, that res judicata doesn't operate perhaps as it should do in investment arbitration because it is difficult for states to establish that the principle applies. And if you're looking at the triple identity test, that becomes a problem. On this point, the UNCITRAL note on concurrent proceedings in a discussion about lis pendens noted that the triple identity requirement may make it difficult to apply the doctrine to concurrent proceedings in investment treaty arbitration. And so, of course, it's not always the state party that is wanting to apply the principle of res judicata. So it's not always the case that a failure to apply it is detrimental to states. Also, I would say, I think we have seen in these discussions that the principle is perhaps more flexibly applied in cases than this view might suggest. Now, it might not be consistently applied, but it is there is some degree of flexibility. Tribunals have been open to the idea that parties who are privies to each other but not the same should be bound by prior decisions. So the same party test is not always narrowly applied. Tribunals are also open to the idea that the doctrine of res judicata extends beyond just the dispositive part of an award, and that if a question has been put in issue in a previous case and decided, that can have a res judicata effect, even though the issue may not be in the dispositive section. Tribunals have also applied res judicata despite having different causes of action between the two cases, or even cases that are in different legal orders. And we saw from Raid's presentation how important that issue is in the context of local courts. Some tribunals have found differences between contractual and treaty claims. Others have found that they were essentially the same claims wrapped up in a different present, and found that res judicata therefore did apply, even though formally speaking the cause of action was different. The idea of abusive process, I'll do 10 seconds, 15, 30, but no more than 30. The idea of abusive process, as Sam very eloquently made the point earlier, is difficult. It's been applied in very different ways. I don't think we've seen much of the sort of could have been claims, but again, that's an area that might develop. A more flexible autonomous approach would align with the direction of travel that's been suggested by commentators in the commercial arbitration context. And I won't go on to discuss that any further. But to conclude, if there can be anything to be said, I think, for these divergent approaches, it seems to me that at least outwardly, most tribunals have been grappling with trying to achieve what they would consider to be a fair result in the particular circumstances of their case. We may disagree as to whether they got that and whether they actually achieved a fair result. But it's undeniable, I think, that the doctrine and the principles are being used by tribunals in different ways, but are being used to try and control arbitral proceedings. And I'll end that, sorry.
Thank you much, Alex, especially. Especially for showing us these contradicting approaches to res judicata and abusive process. So now we are going to collect comments and questions from the floor, also to our keynote speaker. Please do not hesitate. I also encourage our online attendees to pose questions or comments.
I'll start.
Yes.
Okay. Yes, first.
Yes.
Why not?
Why not?
Hi, thank you. A couple of questions. One I have for Sam. Yes, Federico Ortino, King's College London. For Sam, I mean, it seems to me that you know, many of the issues you talked about and the divergent interpretations sort of go back to maybe arbitrators or tribunals' different approach when it comes to interpreting the treaty. I mean, of course, the treaty is silent in many ways, and sort of they have to deal with it. But I wonder whether you have a sense that that is one of the reasons for the divergent interpretation, interpretations, i.e., maybe some focus more on text, context, whether it's relevant rules of international law or object of purpose, or whether there's sort of a sense if that is at least one of the causes for the divergent results. And if that's the case, whether you would suggest, the right approach. I mean, when you were talking about the mass claims, you did seem to focus quite a bit on the textual relevance, any dispute in the singular. I wonder whether that is perhaps your preference. And for Raid, you talked about this supervisory role that ISDS tribunals have on domestic courts, right? Sort of the reverse. And I wonder what's your feeling about recent trends in treaties where the parties have excluded from the scope of, or the definition of investment, decisions that are ordered by domestic courts, including sometimes also awards by arbitral tribunals. The EU has taken this approach. The CPTPP, not with regard to arbitral awards, but with regard to domestic courts decisions. And recently, I checked the leaked documents of the Energy Charter Treaty, also expressly exclude both domestic court decision and arbitral awards from the scope of investment. But I wonder whether, will that have an impact in this supervisory role that ISDS tribunals have played in the past? Thanks.
Any other questions in the room? I want to waive mine. Okay, let's pick those questions which we have, and then we'll have one round of
I have a question for the keynote speaker.
yes.
Sebastian Lukic, and my question concerns parallel proceedings and whether the principle of committee can play any role, because the Mox plant case was mentioned and there the tribunal considered the committee principle. And my question is, can it play any role?
Thank you. So this is it. Alice, you have your own question?
Sorry. Hi, I'm Lakshna. Thank you for this interesting discussion. I had a question broadly on the topic of abuse of rights. I think many of the speakers touched upon it, so whoever would be interested in addressing it. I want to know if the issue of abuse of rights could be restricted somehow by expanding the denial of benefits mechanism, which is not so prevalent across many treaties, but there is apparently an increasing trend in including such provisions and wide language in new investment treaties. So while we speak of abuse of rights, whether an expansive reading of denial of benefits provisions and more expansive inclusion of these provisions could be a potential solution to this. Thank you.
No, perhaps we can give.
Sorry, yeah, just had one more question.
Sorry.
Yeah, Alex Bakos, Bickel. So my question is mainly for the keynote speaker, but I'd be happy to hear all your views on this topic. So you mentioned at one point that we should be looking at consent, especially on the terms on which it is given. So my specific question is, could we be looking in certain situations at an issue of dynamic consent? So for example, if consent of the state and the interpretation of the jurisdictional clause in a treaty might be premised on good relations between states. And if, for example, geopolitical tensions arise between those two states, could the consent vary in time based on those underlying events?
Okay, thank you. Simon, if you could, yes, please, if you could start commenting.
Thanks very much. Actually, I also had a question for Alexander Slade, which I was interested, but perhaps a bit perplexed by the decision that he's describing, the recent decision, finding a prior decision of the same tribunal not to be final. And I just wonder if he thinks there may be a confusion there between what is res judicata and what is final. Because of course, when you're looking at elective and other cases like Standard Chartered, they've been quite careful about saying, sure, this isn't res judicata because it's not sort of broadly binding vis-a-vis the whole world. But so far as concerns what has happened within these proceedings to which these parties have consented to, once we have decided something, that is final. And that's how I understand elective, and I find that quite difficult to shift as an approach. So the questions. So Federico's question on the divergence of arbitrators and whether this doesn't dictate their approach to interpretation. Well, of course, yes. And hence one of the reasons why there's so much uncertainty, hence why there's so much interest in a multilateral court with a court of appeal, and that could work jolly well if it's sorted out. Federico well knows there are masses and masses of huge issues there. But it is because of that divergence of approach that I was suggesting earlier that there may be useful touchstones out there in terms of those principles I was pointing to from the ICJ jurisprudence, in particular critically important principles as to consent. Of course, as I was also saying, the ICJ is not always that useful because it's looking at matters in a different or specific context, such as diplomatic protection. So we have to be a bit careful. But, you know, just as Johnny Vida in your tribunal is sort of looking back to Henderson and thinking that is a useful touchstone, so I think within the ISDS world, where of course we are applying international law, it is useful to have in mind how the ICJ or other state-to-state tribunals have looked at very similar issues in similar contexts. And that might help address the issue of divergence. You know, so far as concerns myself and the need for focus on the text, well, I would say, well, yes, you know, that's kind of what Article 31.1 BCLT points you to. But I say that with, you know, a question mark next to myself, because of course, you know, the person deciding Adamakopoulos, the president there is Don McRae, who's obviously an extremely powerful jurist, and who has indeed sat as an ad hoc judge on the ICJ. So somebody to be taken very seriously indeed. On the issue of comity, well, that's a very interesting question. I'd be a bit wary as comity is like a sort of a broad principle. I'm not sure it applies really. And one sees how less and less frequently it is referred to, including in the domestic context. If you think, for example, of non-justiciability cases within the English courts, well, how less and less people are interested in any idea that an English court might not trespass into the question of whether the US is allegedly breaching such and such a norm in its operations, for example, in Thailand, if you think of the Belhaj case. But I do think there is a sort of comity that plays through in cases where you are seeing weight being given to tribunals to the exclusive dispute settlement provision in a contract. So the tribunal is saying, well, hang on a sec, I'm not going to decide that because you, the person before me, have already consented to that being decided in a different forum, and you can't now row back from that. And you could see that as a form of legal comity. The other question on consent and geopolitics, broad geopolitics, and how is that shaping or potentially shaping people's approach to consent? Well, you can at least certainly see tribunals shaping their decisions so as to establish jurisdiction against very difficult geopolitical backdrops where there may well not be consent on a more obvious reading of the treaty. There I have in mind the approach to territory and what is meant by territory in the cases involving Ukraine and Russia.
Thank you.
Okay,
In terms of,
I'm happy to.
Right.
Yes, of course, of course. I'm happy to just briefly. We have a mic. Thank you. To just briefly touch upon your question, and happy to hear also from others about this sort of trend of excluding from the definition of investment domestic court decisions. I think I'll give you the easy answer. It will depend on the facts of the case and how each matrix. And why do I say this? Narrowing down the ratione materia scope of the jurisdiction of a tribunal under the guise of definition under the BIT definitely would probably have an impact. But I think you can still bring it through another, backdoor, because then you'll have the denial of justice. You have the other treaty breaches that can pertain to the conduct of the judiciary, although the focus would not be on the decision itself, like in SAIPAM being the investment, or focusing as a court decision being the investment itself, but the conduct of the judiciary would still be captured by other, I would say.
Just a habit that you can just simply evade by going to other provisions and claiming breaches of the provision indirectly by the court decision. Right?
Absolutely. That's, I don't know, but you may have more insight.
Wasted ink.
Not that much, perhaps, as a state counsel, I would say not absolutely, but well, you always can claim that, in arbitration that, in fact, this claim circumvent the definition of investment, and in fact, is against the letter of the wording of the treaty. Always an argument.
Or more money and
Something
time
to
spent.
think for the arbitrators.
Sorry. Or money or time spent on jurisdictional objections, which may ultimately not maybe make a difference. Anyway.
Enjoy to the merits.
I'll just quickly touch on two of those questions. Sam's first on Cavalum. I mean, Sam, I think I agree with you. I do wonder. I mean, so the tribunal went on to acknowledge that some form of finality is desirable, and they quoted with approval another comment from Standard Chartered Bank, which was that I'm quoting, a decision of an ICSID tribunal cannot be considered to be merely a draft that can be reopened at will. So at least as exactly, at least as I see it, and I'm speculating, of course, but I suspect that the decision that they had looked at the issues that Spain wanted to reopen in their original decision, and we're not going to change that decision, maybe contributed to allowing it to be reopened for the purposes of looking at it and then deciding that it was fine. The issue, I think, in this case was that the Comstroy decision had come out after the original decision on jurisdiction. And so the argument was, well, now that is out, it's a new thing you need to reopen. But the tribunal thought all of the same issues had already been addressed when we made our original decision. So I do wonder whether that contributed to a willingness to reopen it. But I don't know. I agree with you that as a basic principle, that those kinds of decisions should be final. And just one comment on the comity point. I do wonder whether I think I agree that the comity itself may not be that helpful as a principle, but there are other tools that can be used. I think res judicata, applying that more broadly, can be one of those. Abusive process, that those are the kinds of tools that could be used to help to control parallel proceedings. And Sam's idea of consolidation again is a good one that we don't see enough, but could very much help with those kinds of things where the parallel nature of the proceedings comes basically right from the start, because there are multiple claimants within the same investment group. Yeah, thank you.
Shall we conclude, Eric? Okay, thank you much. Thank you much for the keynote, and thank you much, panelists, for your interactive presentations. We have now a break and then we turn after the break. Thank you.